I'm the first one to do the presentation, so I have to get a little bit of visuals and a little bit of attraction for everybody to get to understand what is investor-state arbitration. There are so many bilateral investment treaties. There are so many multilateral investment treaties, more so the ones that Virginie mentioned, the ones between China and Pakistan, the ones between the investors that come into the CPEC engagement. They rely on their country's bilateral investment treaties with Pakistan, or the multilateral investment treaties that Pakistan has. The very first bilateral treaty that was ever signed in the world actually was in 1959. That was between Pakistan and Germany. And more or less, these bilateral investment treaties have similar provisions, which we will quickly touch base. I won't go into a lot of detail because I have to speak very fast, run very fast, and we won't have enough time for Q&As. So there is a built-in arbitration clause in a bilateral investment treaty. We'll come to that as to why do we need to have a signed agreement and why a signed agreement doesn't really matter when there is a treaty-based arbitration that provides a cause of action for arbitration. If you see, we will go through a few things. I won't repeat what is written on the slides. You can read faster than what I speak. The fun fact is that Pakistan received a notice last year from Saudi investor, and they are relying on a cause of action that arises from the OIC arbitration treaty. It is not because of the agreement between the K Electric. It is not because of the agreement between the K Electric and the investing authorities, or the consortium in this case. And that is no longer an ad hoc arbitration. They have an arbitration center now set up in Istanbul, Turkey. A little bit of flashback. The Rico Dick case, the cause of action was based on Article 12 of the Australia and Pakistan arbitration bilateral investment treaty. It was not based on the Chaghi Hill exploration joint venture agreement. The Supreme Court declared the joint venture agreement is invalid back in 2019, but the ICSID assumed jurisdiction based on the cause of action that was based on the treaty-based arbitration. You cannot invalidate a treaty because there is a Vienna Convention. Anybody else? Everybody knows that Vienna Convention on the laws of treaty. So it's not easy to back out from a treaty unless you renounce the treaty, unless you abrogate the legislation that transposes that in your jurisdiction. So with that, of a little bit of glimpse into what investor-state arbitration is all about. It's not based on just in the agreement. Anybody who wants to know where the treaty is based, this is a multilateral investment treaty. You can download it from the OIC website. It has all the provisions. I'll just highlight a few of them, which is Article 17 of the OIC investment agreement, which is agreement for the promotion, protection, and guarantee of the investment. It was signed back in 1998 or 89, I believe. And it gives you a definition of investor. It gives you a definition of investment. I've highlighted the operative part of the definition in a paraphrased manner, which gives it's a contracting party. It can be a government. It can be a private party from the outside. Hence the earlier slide of a Saudi private consortium sending a notice to the government of Pakistan. Oh, we have a dispute. Well, we rely on the arbitration that arises from the treaty, not from our agreement. And then you have a definition of a capital. Capital is what they have transferred in, which is their assets, which is the profits, as well as the dispute. Sometimes arbitration agreements do have a definition of a dispute. Sometimes they don't. This one does not have. This is the bilateral investment agreement. This is the multilateral investment agreement. In this particular instance, the definition of dispute doesn't exist, but of course, when there is a breach of the provisions of the multilateral investment agreement, that does provide a cause of action to the investor. There are a few ways which we will highlight as to what kind of breaches. Host state is very much vulnerable. It has to treat all the investors in a very, non-discriminating manner, even-handed manner. So it can be, where they are not providing, enough permit. I have to read up my slide to turn around. Where they are fails to provide the permit to transfer the capital, they are failing to open up various field of investment. The host state fails to provide necessary facilities for residents' work and all that stuff, the logistical support, as well as the whole state fails to respect the rights that have accrued to the investor over the period of the agreement, as they earlier to that and before that. The Chaghi Hill Agreement was signed back in 1993. The treaty was signed between Australia and Pakistan in 1998. The cause of action arose in 2011. So there's a whole mix of things that make things fuzzy when it comes to the investor-state arbitration. Going to the next slide. Oh, yeah. There are certain guarantees that the host state has to afford safeguards for with respect to the investor. It comes to the transfer of capital because there's a Foreign Exchange Regulation Act, as everybody remembers that, in Pakistan. 1947, created around Second World War time, that restricts foreign exchange. That is a penal statute. That is not a statute that manages foreign exchange. So a lot of investors face that kind of challenge. So those kind of provisions actually come against the state when it comes to transfer of capital because they find themselves handicapped. Then you have the freedom to dispose of property as well as monetary compensation where the state has itself violated any international law or something. Yep, I'm almost done. Then you have a state that is treating investor in a discriminatory manner, and those are the causes of action. I won't go through all of them. And then there are certain defenses. One of the important defenses that a state can take is that they have done their own part and there are certain obligations that the investor needs to do. So his own conduct is contributing to his damage and injury. Those are the things. But not in all instances that you have all the defenses available. Last two slides. And there are ways to address when you are in a dispute. When you are a state, you cannot hide. You cannot, you're there. Any enforcement of judgment is very easy to be enforced against you and your assets around the world. So it's better to settle rather than fight. Don't spend a lot of money on litigation when you can find a solution in an amicable manner. Your settlements are private. Your settlements are not public. Arbitration awards are public announcements, and they can take years to conclude. The arbitration awards are costly. Also, you cannot predict the amount of award. You had $6 billion of award coming out of the RICO one. You have a $400 million claim coming from the Saudis under the OIC cause of action, and we are almost done.